This is Nick Falvo coming to you from Ackerman's Washington offices, where today I want to give you a brief summary of APSCU's May 20th oral arguments in their lawsuit against the Department of Education challenging the Gainful Employment Regulations. Again, on May 20th, APSCU presented their arguments before Judge Bates in the District of Columbia Circuit of the federal bench. The demeanor in the courtroom was much more favorable for APSCU than what Judge Kaplan in the Southern District of New York was towards APC. A major focus of the hearing was on the full statutory language of prepare students for gainful employment in a recognized occupation. Specifically, those last four words of in a recognized occupation. There was a secondary focus on the recent basis of the change from the 2011 proposed two-part test to the 2014 single test and single metrics. First, APSCU claimed that the rules were unauthorized under Higher Education Act and contrary to the Administrative Procedures Act. Specifically, the rules do not measure gainful employment, but rather they measure student debt, of which there is no reasoned and rational basis between the two. For example, gainful employment could simply be proven by something such as a letter from the employer or a tax return. Additionally, looking at a dictionary definition of the phrase gainful employment, APSCU would say that in its ordinary meaning, gainful employment means a profitable job, or a job that pays. Meanwhile, according to APSCU, the department would want the judge and would reword that definition to mean a job that pays and earns enough to pay off student loans. As I said, there was a major focus on those last four words of in a recognized occupation. This was something that was not being litigated upon and that Judge Bates presented in his own ways. When asked by Judge Bates what in a recognized occupation would mean, Doug Cox, who was representing APSCU, said it would be a real job in a real economy, in a legitimate job, not just a meaningless job. Compare that to Marsha Berman, who was representing the Department of Education, who said it would be a skilled job and not a meaningless job such as a babysitter. However, Judge Bates presented a hypothetical situation and scenario where a student who was going to a for-profit school to become a dental hygienist was able to pay off their loans first as a dental hygienist and second as a receptionist. Noting that in a recognized occupation, that was in the statutory content. To APSCU, this makes a big difference under the statutory language, and specifically that the student was employed in that recognized occupation. Meanwhile, the rules do not make a distinction between a job and a job in that recognized occupation. The rules make an assumption that the income is tied to the skilled job which the student worker is trained. Personally, I think that was a major sticking point that Judge Bates pursued, and it could be something that, even though it wasn't being litigated in all the motions leading up to the oral arguments, that this could be something that could swing the opinion. Moving on with their argument, APSCU said that the rules were a bad fit under the Administrative Procedure Act. Specifically, during oral arguments of APSCU 1.0 or GE 1.0 litigation in 2012, the department argued during oral arguments before Judge Contreras that neither of the two tests at the time could stand alone. Now, the department is really only employing one test. APSCU argues that this is arbitrary, capricious, and irrational. The department basically came back and said, well, that's just semantics, and that there's different levels of this test. And, well, their semantics is just plain wrong. APSCU also presented the scenario that two schools offering the same program at the same tuition and same fees, but in different locations, could have two very different results under this one test, dependent upon personal student choices as well as local economic factors that are not considered by the rules. However, the department maintained that the schools can challenge the metrics and thus results of the debt to earnings test. Additionally, Judge Bates did say that schools could help with that scenario by helping their students gain more jobs. In terms of potential effects on schools, APSCU claimed that schools would be more selective as to what applicants they admit and thus change the student demographics. They were citing a Washington Post article that said just that. Also, APSCU said that schools would voluntarily close because they would not be allowed to draw from Title IV educational funds. The department does contend and counter that schools will not need to close. However, they will just not be eligible for those Title IV funds for that particular program. Third, and this might be a big point later on, and I'll explain that in a second, that students will not have an opportunity to continue their education. Here, the department makes the assumption that local schools, surrounding schools in the same general area, or other programs offered by that same school will be able to absorb or re-enroll students who may be losing or whose programs may be forced to close or suspended. APSCU vehemently says that these students will not be able to continue their education and will be shut out from the higher education process. And then lastly, fourth, up to 1/3 of all students will not have the required hands-on education necessary for their programs. The department, meanwhile in defense, said that, well, APSCU is still wrong in the statutory authority. And this goes back to the Gainful Employment 1.0 litigation in 2012, saying that the Higher Education Act is ambiguous and that the department is able to promulgate their rules as long as they're reasoned. When asked again, pursuing that dental hygienist scenario by Judge Bates, Marsha Berman, the attorney representing the Department of Education, said, and not only the dental hygienist, but what does in a recognized occupation mean? The department responded to say that it was a skilled job and more than just a babysitter. As I mentioned earlier, the department did concede that the rules assume that the income is tied to the skilled training that the student is educated in, as long as that student is able to repay their loans. And then going to the gainful definition and the dictionary definition, that it would mean a profitable job, meaning that there would be a return over the investment of the education. Furthermore, the department also said that the rules complied with the Administrative Procedures Act. In other words, the department considered all alternative viewpoints leading into the discussion and draft of the rule, in the final draft of the rule, and then they gave a reasoned explanation once the decision was made, and that's all they need to do under the Administrative Procedures Act. Second, in another regard, that 8% mortgage industry rate that was highly contended, well, the department says that it is widely accepted and longly accepted within the educational content. On rebuttal and in closing, APSCU said that the department cannot condition Title IV eligibility and funding on the amount of debt that Title IV and only Title IV students carry. Furthermore, the Higher Education Act, and the language specifically, is about preparation and jobs. However, the rules are about outcomes and debt. So where does this leave us at the end of the APSCU litigation? Well, we're very happy that Judge Bates was able to hear the arguments before Judge Kaplan was able to rule on the APC litigation up in New York. Further, though, we do suspect that Judge Kaplan, because he did have a 2 to 2.5 week head start in hearing his case, that Judge Kaplan will rule first. But the important part is that Judge Bates did hear the matters on the issue, and that he will be given an opportunity to give his opinion. We will keep an eye out on everything, and we'll update everyone as developments occur. Until then, have a great day.